So, hello everybody. We are going to start the rest part of the parliament. And I told you we have discussed Lok Sabha, Rajya Sabha and their composition also. Then just let me repeat you the things to some extent. That is, territorial representation is there. Territorial representation. There is territorial representations. In Lok Sabha. What does it mean? It means that the geographical territory of India is divided into certain electoral constituencies, and each constituency sends a member to Lok Sabha. There is territorial representation, hence there is reservation for SC and ST according to the proportion we have already discussed. Another thing, the delimitation of the constituencies is done by the Parliament under delimitation commission, which is established by an act of Parliament. So probably I have told you that there have been 4 delimitation commissions constituted in India so far. The first delimitation commission was set up in 1952, and the last one was in 2002. They reorganize or readjust the electoral constituencies on the basis of increasing population. And remember, the recommendation of the delimitation commission are not subject to judicial review, or not subject to parliamentary debate or any type of change by the parliament. So it is a sovereign body, or you can say it is quite an independent body with regards to delimitation of constituencies. Last delimitation was done in 2002, and there has been no increase in the number of seats, rather there has been only readjustment. And I told you that there is, by 84th Constitutional Amendment Act 2001, there was a ban on the total strength of the Lok Sabha and Rajya Sabha and other Vidhan Sabha and Vidhan Parishad until 2026. So that is the things. Another thing we have to note also, the present delimitation has been already been done on census 2001 after 87 Constitutional Amendment Act 2003. 2001 census was taken as a consideration, as a point of consideration with regards to delimitation in India in 2002. And since then there has been no delimitations occurred in India. It will take place probably after 2026, after the elections. Okay. So there is reservation, and we have already also discussed nomination process, and the provision for nomination of Anglo-Indian members has already come to an end by 104 Constitutional Amendment Act 2020. So this is the things. Now we shall come to the membership. We shall come to the membership of Parliament. We shall come to membership of Parliament. We have already discussed. Okay. Before membership, let us have a brief idea about the duration of the houses. Duration of the houses. Duration means term of the houses. Lok Sabha has a term of Lok Sabha as a term of 5 years. That is counted from the first meeting. First meeting of Lok Sabha, or first meeting of it. That is also a point to be remembered. The 5 years is counted on the first meeting of Lok Sabha. But Rajya Sabha does not have a term. Rajya Sabha does not have a term at all. It's a permanent house. So Rajya Sabha doesn't have a term. It is a permanent house and it is not subject to dissolution. And regarding one-third members of Rajya Sabha, retire at the age of retire at the end of 2 years. So it is a house which undergoes cyclic vacancies, and those vacancies are filled up within the time. So there is no term of Rajya Sabha because all the members do not leave the house, vacate the house simultaneously or at a time. With regards to this provision, a term of Rajya Sabha member, it's 6 years. That is as per the Representation of People's Act 1951. The duration of the house is like that. Another thing you have to note also, most important part also, the term of Lok Sabha can be extended by 1 year during national emergency by the parliament also, and both the houses have to approve the things in special majority. Then only the term of Lok Sabha will be extended during 1 year, for 1 year at a time, and election will be held within 6 months from the date of revocation of revocation of emergency. So it cannot be suspended, it cannot be extended for another 6 years after the end of, more than 6 years after the end of the emergency. So it is a unique kind of system that can be held, that can be implemented in India. So that is all about your articles, or your duration of the house. Duration of the house is someone's Rajya Lok Sabha duration is maximum 5 years, but remember the term is not fixed one. Lok Sabha will continue for 5 years if the government ruling party majority enjoys majority in the both houses, and it has got a majority in the Lok Sabha especially. So Article 83 contains duration of the houses of parliament. So if we examine Article 83, you will see. If we examine Article 83, you will see that The Lok Sabha bears, Lok Sabha has a term, but Rajya Sabha doesn't have a term. And the Council of State is not subject to dissolution because it is a permanent, that is 83(1) में ये कहा गया है, 83(1) में. And with regards to Lok Sabha, it is 83(2) में कहा गया है कि the House of People, unless soon or dissolved, shall continue for 5 years from the date of appointed its first meeting, and the expiration of the said period of 5 years shall operate as a dissolution of the House, provided that said period may, while proclamation of emergency is in operation, be extended by Parliament by law for a period not exceeding 1 year as a time and not extending in any case beyond a period of 6 months after the proclamation has ceased to operate. You are getting the point? So from the date of ceasing of end of proclamation of emergency, election must be held within 6 months. So at the best, Parliament can continue for another 6 months within the elections until the election is held. That is also a constitutional obligation. So Article 83(1) talks about the term of Rajya Sabha. Rajya Sabha has no term because it is not subject to dissolution, but nearly 1/3 of its members shall retire as soon as may be on the expiration of every second in accordance with the provisions made in that behalf by Parliament by law. So Parliament has enacted Representation of People's Act, which governs the duration of the houses. Got it? So that is the things. Now shall come to the membership of Parliament. Membership in Parliament. In a parliamentary democracy, members of Parliament hold very important or significant positions. They are the representative of the people of India, and they are responsible, and the onus, you can say the onus of success of democracy lies on their heads, because they are to ensure that good governance is presented in the House and good governance is there. So members are not as you think that they are ordinary members, but they hold a very important position in our parliamentary democracy. Okay. So qualification of the members we shall discuss. So members are essential part of the parliament, and the success of parliamentary democracy solely depend upon the adequate and democratic style of functioning of the members, and their prudence, their wisdom, their knowledge in making Parliament a forum of discussion and deliberation to reach a conclusion with regards to national interest. So role of members in success of parliamentary democracy is paramount. In this part which is called membership of the Parliament, we shall discuss the qualifications and the disqualifications. We shall discuss the qualifications and disqualifications of the members. So the qualifications of the members are found in Article 84 of the Constitution. So let us examine what are there in the qualification of the Parliament. What are there? We shall see. We shall see what are the disqualification of members of Parliament. Let us have a close look. So Article 84 mentions qualifications. Qualifications of members of Parliament. Article 84. Article 84 makes the Constitution, the Constitution Constitution provides provides the following. Provides the following. for qualifications. That means it is a constitutional provisions to have qualifications. So let us see what are the qualifications. He must be a citizen of India. Citizen of India होना चाहिए. Number 2A भी कहा गया should make an oath that he shall abide, make an oath before nomination, before being elected. He must make a personal subscription or make a personal authorization to the election commission for the purpose that he shall bear true faith and allegiance to the constitution. He shall uphold the sovereignty and integrity of the country. So as a member, that is the requirement also. So the constitution provides number 1, number 2 should make an oath before the election commission. Before any person authorized by the parliament. Number 3, he must be authorized by the election commission of India. Number 3, 30 years, 25 years for Lok Sabha and 25 years for Rajya Sabha. That is also a point. And the parliament may okay, so must be 25 years. And also number 4, any other qualification added by parliament under a law. Got it? So accordingly, parliament has added many certain changes in the qualification also. Here it has added certain things. Okay. So let us see what are added under Parliamentary Act by Representation of People's Act 1952. So Parliament has added a couple of qualifications. By under Representation of People's Act . Number 1, he or she must be registered as an elector of an elector, must be registered as an elector for a parliamentary constituency. must be registered as a voter. But prior to 2003, there was a requirement that a candidate contesting an election to Rajya Sabha must be an elector and resident from that state. But in 2006, in 2003 it was abolished. So there is no requirement to be for a person to be a member, to be an elector in the state in order to be elected to Rajya Sabha from that state. So that is also a point to remember. She must be registered as an elector for a parliamentary constituency in case of both Lok Sabha and Rajya Sabha. Number 2, he or she must be a member of scheduled caste or scheduled tribe in order to contest the result So these are the major qualifications that has been added. Remember, any change in the qualification, any addition, any deletion or any substitution can be done by Parliament only. Neither the state legislature nor any authority is empowered to add any qualification to the members of Parliament. That is pointed to be noted. And as you have gone through the qualification, you can see that there are very genuine qualification or congenital qualifications which is not it's commonly found for each person. So as it is a democracy, we have to remember that these are essential also. Okay, and another thing, the SC/ST in the contest election, but the SC/ST can contest from general seat, unreserved seats, there is no problem. So, but in order to contest in SC and ST, there is a chance. So she must be a member of SC and ST. Okay, and now we shall come to the disqualification. Disqualification of members. Disqualification of members are both types, means discretionary, ONARY, discretionary power of Parliament. So here also you have to remember that disqualification on the constitution shall be qualified being statutory members. So the president members of Parliament are disqualified by the President members of Parliament are disqualified by the President on the opinion of Election Commission of India. Okay, that is found in Article 102. So, disqualifications. Under what ground the President may disqualify the members? There are a lot of grants provided under that is the builder. Okay, so let us see what are the grounds of prohibitions. Holding office of profit, holding office of profit in India. Number 2, unsound mind as declared by competent court. Unsound declared by competent court, by a court competent enough. Number 3, discharged, insolvent, undischarged, insolvent. Number 4, acquisition, acquisition of a these are the disqualification provided under Constitution, and it also authorizes the Parliament to make provisions. Parliament to make provisions, and accordingly Parliament has enacted 1951. Okay, there are various grounds under Article 161 of the Constitution, but let me discuss you some major points that will work for you. The disqualifications disqualification under Anti-Defection Act. So defection means changing the political party from one party to another. There have been frequent collapse of government after independence, especially after the end of Nehruvian and Indira era. Seldom one regional party could muster the required majority in the parliament. That was a very negative development of the democracy. But disqualifications under Anti-Defection Act 19. For this reason, Anti-Defection Act has added many provisions to retain majority of the members in the Lok Sabha and Vidhan Sabha. So what are the points? First of all, members shall be members are disqualified under NDA Anti-Defection Act 1985 on the following grounds. If he or she voluntarily or joins any political party after election, next, an independent member so an independent member joining any political party next if a nominated MP joins a political party